All right, next case will be Befanis versus Befanis. Excuse me.
Good morning, police court. My name is Doug Marks. I represent Paul Befanis, the appellant in this case, and I'd like to reserve 5 minutes for rebuttal if I could.
All right, you may proceed.
In this case, the
Befanis, is that the correct pronunciation?
Befanis, yes.
All right, thank you.
In this case, the trial court denied Mr. Befanis's petition for modification of his alimony on the basis that a prior stipulated final judgment in July of 2016 had contemplated what the trial court referred to as a pending retirement of Dr. Befanis. And the trial court also premised its ruling on a finding of credibility on behalf of Mrs. Befanis as opposed to Dr. Befanis on that issue. On the issue, if I could address the testimonial credibility issue, I think if you look at the testimony closely, you'll find that there really was very little discrepancy between the parties on the issue of retirement in general, and that the record really doesn't support a credibility determination. Dr. Befanis...
Let me ask you this, because there are two difficulties I have with your position in the case, and that is that you had a pleading that specifically said that this is in contemplation of retirement, and his lawyer drafted that pleading, even though he wasn't retired at the time that this was going on. I guess the lawyer said in his pleading that he'll be retired by the time this gets to court, was his allegation. And then the second thing is that he testified that at one point in the hearing that it was in contemplation of retirement. So why don't you, those are I'm troubled by both of those.
Let me address the pleading issue first. When that petition was filed, he was not retired. He was seeking a modification, and he had not yet reached age 65. He was seeking a modification on the basis of a reduction of income, and thus was subject to a voluntariness or involuntariness argument under PIM.
But the pleading didn't say, the pleading didn't say, I've had a reduction of income. The pleading said that this is he's going to be retiring. This is in contemplation, effectively in contemplation of retirement. And then his testimony, I'm sure, was a complete shock to the lawyer, but that's what he said.
The pleading alleged a reduction in income, and in addition, on the basis that he had sold his practice, he had entered into an employment agreement with the purchaser, and he was now making substantially less. The pleading went on to say that this case may not be completed until he goes past the age of 65, whereby he would be entitled to either retire or reduce his workload, and if he did so at that point, he, under PIM, would not be voluntarily reducing his income. He would now be over 65 and be entitled to do that either through retirement or a reduction in his workload. So the basis of the actual seeking of relief in that pleading was a reduction in income based upon the fact that he had sold his practice and was now a contract employee. His testimony at the 2019 hearing was, I contemplated retirement at the end of my employment contract in September of 2018. The wife's testimony was basically the same. She said it was her understanding that he was contemplating retirement in 2 or 3 years. This was at the time they entered into the stipulated final judgment in 2016. So their testimony was essentially the same. He was contemplating retirement not at the point of entering into the stipulated final judgment, because at that point, in fact, he had not retired, that he was contemplating retirement at the end of his employment contract.
Right. Counsel, I do understand your argument. You're essentially saying he was sort of justifying his reduction in income by pointing to his age and his retirement when he filed that original motion or petition. But what I want to look at is, so the second prong of Prim is, did the parties contemplate, not did the final judgment mention it, but did the parties contemplate the change at the time of the order? And by the very terms that they're talking in, it was clear they contemplated his retirement. And there's a lot of cases where maybe something has not happened at the time the order is entered or the judgment is entered, but that's not the standard. It's whether they were contemplating it. And I think all the testimony points and the pleadings point all that he was clearly contemplating it at the time that second modified order was entered. How do you propose that we get past that?
He was contemplating a future retirement in September of 2018, which puts him in no different situation than the alimony payor in the Delgado case, who contemplated retirement and inquired about it every year for 10 years.
Let me quote his testimony.
His testimony was...
I'm going to read it to you. I don't want you to tell me. I'm going to read it to you, and then you tell me if I'm getting it correct or not. When you entered into this agreement, okay, were you doing it in contemplation of retirement? His response to that was yes.
Yes, sir. He went on to say that...
I understand he went on to say, but the question is, did the trial judge have evidence on which to rely upon? The fact that he then backs off from that when his lawyer was probably just just shocked at that answer, and he starts backing off from it, and I get that, and I understand some other issues that we're going to address with the other side, but that's a little troubling.
Well, I think when the court indicates he backed off from it, I would suggest to the court that he explained it. What he explained was, I'm in this interim situation. I'm not yet retired, but my income has drastically reduced from somewhere $900,000 to $1 million to $310,000. I'm still paying the original alimony. That he testified that he fully contemplated that when he actually retired, that he would file another petition. He testified that he had no concept that he would be precluded from doing that. And most importantly, the former wife, nor he, testified that the figure in the stipulated final judgment was the result of any consideration of actual retirement and what his retirement income would be. So while he contemplated...
But then the answer to that question should have been, no, I'm doing this because I've had a reduction in income.
Well, certainly that would have been a more beneficial answer, but that was the purpose of the further explanation of his answer. So, and I would respectfully submit to the court that the outcome of the case should not be a game of judicial gotcha that you...
This isn't a judicial gotcha. This is an evidentiary statement by your client.
No, I understand, but he perhaps could have phrased it better, but he went on to explain what he meant. And what he meant was, and the undisputed evidence, there was nothing to the contrary, that he was contemplating retirement at the end of his employment contract, not at the point that he reduced his alimony because it was out of correlation to his present income.
I'm sorry, go ahead.
Let me ask you this. Although generally we refer to contemplation, the Supreme Court really didn't follow that in PIM, in my mind, because people start contemplating retirement when they're 25 years old, 30 years old, 35 years old. So obviously it doesn't mean that if you enter a marital settlement agreement at 40, you're contemplating, that when you retire, the amount of your alimony obligation won't change. And PIM basically, to me, says that. But they don't address what the test should be. So Bauchman kind of talks about it, because otherwise, if you follow that contemplation prong to a T on retirement, that means no one could ever get a reduction in alimony when they retired, whether they were 65, 75, 80, or whatever. But if we write an opinion favorable to you, what's the language you'd use?
Well, the first language I'd use, as we argued in our second argument, is to reconcile Bachman with the long line of cases that talk about settlement agreements to be contracts which should be interpreted as other contracts. This settlement agreement, the stipulated final judgment, was absolutely silent on the issue of retirement, contained no words that had ever been considered, and was unambiguous on its face. So reconciling Bachman with that line of cases, the opinion, in my view, should read that if you want to argue or hold that the prior agreement had contemplated retirement, that should be, in the Bachman language, accounted for in the agreement or the judgment, which
Yeah, but, to me, that agreement seems like both sides didn't want to get into that. So they just said, we're reducing the alimony obligation to this. Maybe that was a point of contention about what the language would be as to why. So I'm not sure that favors one side or another. Y'all basically made an agreement. We're reducing the alimony from this amount to this amount.
Well, that sort of goes to my point, is there was nothing in the record as to the specifics of how this figure was arrived at, or there was no testimony that, for instance, the former wife didn't testify that this was based upon his actual retirement. She didn't testify to that. She testified that I was led to believe that he was going to retire in 2 to 3 years. So Dr. Befanis was in this situation where he was clearly contemplating retirement. That's undisputed, but 2 years down the line. But in the interim, he was faced with a situation where, as his income was staircasing down, as his career was coming to a close, his income was 2/3 less than when he had the original divorce, setting the $12,500 alimony figure. So he entered into an agreement that was silent on retirement, but was certainly commensurate with the income that he had.
Let me ask you this. If there had not been an agreement and they went to trial, what income should the judge use in determining alimony? The $350,000 plus investment income, or Social Security plus investment income?
Are you talking about the trial of this case in 2019?
No, if they, instead of the settlement agreement, if they'd gone to trial?
I don't think, but I don't specifically recall if he was receiving Social Security at that point. I don't believe he was.
No, he wasn't. I think you're missing,
Right.
you're missing the question.
Yeah, with the trial judge, if the case had settled, instead of settling, back when they did the agreement for, was it $7,500? If instead they'd gone to trial the following day, what income should the judge have utilized in determining the petition?
$310,000, his actual earned income at that point, plus whatever he was earning passively on his investments. There was no.
Do you agree that let's say hypothetically we agree with your position on that what the result is a remand? Would you agree?
Yes, sir.
Okay.
Yes, a remand for consideration of what the reduced, if any, reduction figure should be. So if I could reserve the rest of my time for rebuttal. Thank you.
May it please the court, counsel, Clay Morgan on behalf of the appellee, former wife, LYNNE SOMMER-BEFANIS. As you know, this case arises out of a petition for modification of a final judgment. The initial final judgment entered in 2010 provided for $12,500 in permanent.
We're aware of all that.
Mr. Morgan, let me just, kind of the same question I asked Mr. Marks. If instead of the settlement agreement they got on trial, would you use a figure of retirement, that is Social Security plus investment income, or would you have used the $310,000, $350,000, or whatever it was?
Well, I think at the trial, we would be stuck with what he was earning plus he had just sold a $5 million practice, so you had investment income off of that or whatever.
In fact, it would have been error for the trial judge to have done anything other than that, correct?
Well, I think the trial judge could have addressed at that point the fact that he was contemplating retirement. They could
I
have.
don't think, that's an event that's going to happen in the future, and I don't think that the trial judge at that point in time could have said, well, I'm going to take a look at this as if this event occurs when it has not yet occurred. It seems to me that that would have been error for the trial judge to have considered his financial situation as if he had retired. He would have been required to have looked at what his income was and what his investment income was and what effectively need and ability to pay as of that date, and that it would have been error for him to have viewed this as if he had retired.
I think that that's correct, Your Honor. I think that the judge would have been able to address the retirement issue and the potential time frame that he was pleading.
So if they'd gone to trial and the judge utilized a figure based on 310, 350,000, whatever it was, and then 2 years later he completes the contract and now he's getting Social Security income plus investment income, would that be a basis to get a reduction? Saying, look, I'm earning less than I was before?
Well, I think you're making the assumption that during the time frame that we were arguing all of these issues and came to that stipulated final judgment, that we weren't discussing the fact that it contemplated the fact that he was going to retire.
He hadn't retired. That's the point. That was the point of Judge Evander's question, is that he had not retired.
That is correct. He had not retired. But the question is whether it was contemplated of the parties during that time frame that he was retiring.
The reduction of alimony was almost exact, certainly within close proximity of the reduction of his income from the $1 million plus down to the 300,000. And my calculation on that it was around 40%. It
was approximately 40%.
Okay. Which is, so that his alimony reduction mirrors the reduction of his income down to the contract price, what he was earning on the contract. Is it your position that's a coincidence?
No, so there was a lot of variables in this action that were at issue back then. There was $5 million of investments, there was houses, there was properties. So there was a lot of balls in the air, if you will, as far as his income goes. So to address that percentage in line with what his actual income at that particular point with, as far as just his salary, it was not the basis for that number. It was a negotiated.
It's a coincidence.
Like I said, I didn't really go back and we didn't go back and look at all the figures that were based on that, but there was $5 million in cash in play. There was businesses that were still in play. There were retirement assets that were in play, and then there was a salary that was in play from his businesses and a residual income from accounts receivable. So there was a lot of income that was not just addressed in his $300,000.
Wouldn't it have been easy to have put in the agreement, this is in contemplation of complete retirement?
I mean, I guess we could have put in a lot of different things in the agreement, Judge. We could have put more things.
And I recognize, that it's easier, a lot easier for us, sitting up here in hindsight to pick apart, what occurred, and I get that, and I'm not critical of the fact that it's easy for us. I understand that dynamic, but it just seems that if that's what you wanted to do, it was easy enough to do.
Well, at that point,
and it wasn't done.
When the agreement was agreed to by the two of us, we simply put a simple stipulated final judgment into effect and submitted it to the court for signature. We did not go into a lot of detail at that time. Bachman came out about a month later, maybe, obviously, and so in hindsight, we might have been a little bit more verbose in our findings, but in this situation, the question is, was it contemplated? And both parties in their testimony before the court, the trier of fact in the petition for modification, said that it was.
Would you agree that the term contemplated when it comes to retirement is a little different than other situations? I mean, I contemplated retirement when I was 25, retiring at, in my 60s sometime. So, and it's foreseeable. I mean, obviously it's foreseeable when I was 25 that I'd retire sometime. So my concern on this case is, in essence, by reaching the decision that the trial judge did at the conclusion of the trial, she's almost assuming that 2 years before she would have set that the parties contemplated income of Social Security plus investment income when that wasn't the case, and if it had gone to trial, she wouldn't have been allowed to have done that.
Well, I think that the judge in the lower court wasn't going back and saying what would have happened 2 years before that. The agreement was made. The judge was making a determination based upon what the parties were testifying to in front of her. She was saying...
It's an interesting point. After the doctor testified that the settlement agreement contemplated retirement, which seemed to me to be a fairly good answer for you all, your client objected and stated that the agreement speaks for itself, and that objection was sustained.
Right? Well, Your Honor, there was many questions beyond that. I mean, there wasn't.
But that's a critical statement that he makes that really, at least on its face, until he goes on and explains later. But that statement on its face is very helpful to you all, but yet you object and it's sustained, which effectively is saying, well, let's look at what the agreement says on its face, which was the position that your client took at the hearing, and the agreement's silent.
I believe that's the position that opposing took.
Well, no,
we took the position.
but that objection presupposes that. That objection, and that's what she said. She said, the agreement speaks for itself, and the trial judge, based upon that argument, sustains that objection.
And are you looking at the question that was posed to the posed to Mr. Befanis by his counsel?
Well, it's on, let's see if supplemental record on around 41. Former husband's attorney, well, does the agreement say anything about retirement? Former wife's attorney, objection, judge. The agreement speaks for itself.
Well, that's on question about the...
He's testified to his contemplation, but the agreement speaks for itself, and the trial judge sustains that objection.
Specifically to the question about whether the agreement itself mentions the contemplation. He had already testified that he contemplated it. Yes, I did contemplate it when asked by his counsel, and further by my questioning, went into much more detail about his contemplation, and they had discussed it, and I think I outlined it on page 17 of my brief, all of the times where he said that this was part of that prior action. So
would you agree that the former husband's testimony was that this 5-year employment contract was, in essence, a transition to retirement?
He did, yes, that was his transition.
Did your client disagree with that in any way?
That the 5 years was a transition to retirement? No, I think there was a lot of argument, as any family law case, about what he was doing and hiding money and these types of things, but It was not. His argument was that he was transitioning to retirement always. Back in 2015, when we were arguing it at the trial, it was always there. Matter of fact, I think his testimony is that his plan was to retire September of 2018. He had a specific date at the end of that 5-year plan, and the only thing that he said changed was the fact that he left a year earlier on that transition. So clearly, he had that contemplation of retirement, and it was being discussed by the parties, discussed by the attorneys ad nauseum, but it wasn't included in that stipulated final judgment, that prior stipulated final judgment. But it was, I want to differentiate that from Bachman, from him, from D'Agata. All of those, nobody mentioned retirement. Bachman, which seems to be the strongest case, there was 10 years between entry of the marital settlement agreement and then the entry of then the filing of a petition for modification. So there was absolutely no evidence in the record of any contemplation of retirement, and I think that the Bachman case is very clear on that there was no evidence in the record in their findings. No evidence was presented to show the parties considered former husband's future retirement when the MSA was entered. Well, obviously it was 10 years beforehand. In this case, we're talking about a year and 3 months before this final petition was filed, and there was much evidence in the record where both parties were saying, yes, we were contemplating retirement. We were talking about retirement. I expected retirement here. He gave us definitive time after saying that retirement was contemplated. Yes, he gave a definitive time. Said I was going to retire September of 2018. So that was the very end of his 5-year contract. So all of this was contemplated when the agreement was entered into, and the trial judge was able to listen to that testimony directly from the mouth of both parties, and her finding was that the wife was more credible, that it was contemplated in the entry of the prior stipulated final judgment, and that was her finding of the factual issues from their testimony.
But again, if they'd gone to trial and you got the same testimony, well, you know, Judge, I'm contemplating retirement in 2 years. This was a 5-year transition to retirement. I'm contemplating retirement in 2 years. And the wife says, yeah, that's my understanding, he's going to retire in 2 years. The judge couldn't have said, okay, well, I'm setting the alimony based on assuming that he's going to retire, and I'll just decide, set his Social Security amount plus investment income now, so that I don't have to come back in 2 years because y'all are contemplating that he's going to be fully retired in 2 years anyway. I mean, that would be error, and that's the problem I'm having with your client's position here.
Had it gone to a trial 2 years before, when the stipulated final judgment was entered, there could have been more testimony on his income. I understand.
All right. All right, anything else, Mr. Morgan?
I'm sorry?
Any other argument?
My only argument that I would point out, Judge, is that, as I said, and I think I've made it, the case law is fairly consistent when you're looking at the D'Agata, the Bachman, and these PIM even, that they all find that there's no evidence at the time of the entry of the prior agreement, there was no evidence that there was any contemplation of retirement. Completely different than our case, in which everybody testified about the contemplation of the pending retirement and its effect on his income. Right. Can I answer any other questions, sir?
Thank you.
Thank you for your time. Thank you.
How much time do I have, Judge? How much time do I have?
6:50, I'm sorry.
First of all, I don't think that there was any evidence in the record that the parties themselves discussed this issue of retirement. I think the testimony of the former wife was that she was led to believe, without saying by whom, that he was going to retire in 2 to 3 years. And I don't believe that the former husband testified that he discussed that with his former wife. Be that as it may, I think that counsel's argument shows that there really wasn't a major discrepancy in the testimony of the parties that would have led to this determination of credibility. Everyone was under the understanding that he was going to retire in at the end of his employment contract, which was 2 to 3 years down the road. There was no dispute about that. The fact of the matter is he was in this interim situation where his income had substantially reduced as part of his long-term plan leading to an eventual actual retirement, and it was out of whack with his alimony obligation established at the height of his earning powers. And I think that the testimony that he contemplated a future retirement simply puts him in the category of the Delgado case. I think I called it Delgado earlier. In the Delgado case, that alimony payer, ultimate alimony payer, contemplated retirement not just conceptually in his mind, made actual inquiry every year for 10 years about the details of his retirement plan, and initiated that plan shortly after entering into the agreement and filed a petition for modification just a few months thereafter. And the Delgado court said, well, all he did was contemplate retirement. And I think the Bachman case, which says it has to have been contemplated and accounted for in the judgment or agreement, leads into our second argument in our brief, which is this was a contract. This was a plain, unambiguous contract. Your alimony's reducing to $7,500. There was nothing in that contract that required any explanation, and the court should not have, because the contemplation that the court found was not...
Were there objections to the introduction of parole evidence?
There was not an objection to the introduction of parole evidence. There was an argument twice in closing that the agreement was silent as to the issue of retirement, is my recollection of the record. The testimony that was before the court, no one testified that the agreement that was reached was the product of a discussion of what his actual retirement income would be. No one testified to that. And the only testimony on that point was the testimony of the former husband, who testified, I entered into this agreement on the basis of my actual income at the time I entered into the agreement. And I would just close by saying to the court, the effect of the trial court's ruling long-term is that we have an individual who now has his own living expenses, a $7,500 a month alimony obligation, who has now actually retired, who lives and meets his expenses, including his alimony, based upon his assets and his Social Security, but primarily his assets. And as he depletes those assets over time, according to the trial court's ruling, he can't go back and say, I need a further reduction in my alimony because I'm retired. The court would say, well, you contemplated retirement when we reduced the figure to $7,500, which puts him, in essence, in a financial death spiral as his assets continue to shrink.
Well, but part of this is, of your own making. The pleading that was filed was inartful at best when it says, we're asking for this modification because he's going to be retiring. And so you've interjected that into this proceeding, as well as the one answer, as I indicated earlier, that he gave to a question that was asked. So, listen, we're deciding this case based upon, the posture that you all have put us in.
Sure. Just perhaps repeating what I said earlier, the pleading, if one analyzes it in its full context, the petition for modification was basically saying he was not of retirement age, and he's basically saying my income's been reduced. And he was not of retirement age, and the income reduction was not because he got laid off or demoted. The income reduction was because he had made the conscious decision to sell his practice and accept the contract.
And then he says, and I'll be retired before any action's taken on this petition.
perhaps nuanced, but I don't believe that's exactly what it says. It says, if I go past the age of 65 while this case is still pending, the reduction in income that is the product of my actions to $331,000 because I sold my practice and accepted the contract is not voluntary under PIM because I'm of the age where I'm entitled to do that. That was the allegation in the pleading. And if that allegation had gone before the trial court and that was the only allegation, it wouldn't have supported relief because, in fact, he wasn't retired.
All right, thank you both. Interesting case. And we'll be in recess.